Okay, part 20.
When you were walking down that hall on your way to the apartment, what was your state of mind? What were you feeling?
Sorry, hold on.
Again, I don't think this is faking, people. Anytime she has to relive this incident, it's going to provoke a serious emotional response. She had a significant emotional event in her life. She killed somebody. She knows she's wrong. This is not faking. And I know that people are going to be here saying that she's just faking it. I don't buy it. And I've been around a lot of people. I've been around fakers, and I've been around a lot of things, and I'm not seeing this as faking.
I was calm. I was relaxed.
Were you paying attention to mats, things on doors, anything like that?
I was just going home, so all I wanted to do was go home.
Mr. Ernest asked you questions about burglary calls, taking cover, asking for backup, asking for K9. Did you feel in any way this was a burglary call you were responding to?
No, I was responding to my own home.
Actually, she wasn't responding. She was in a relaxed state, going home, not expecting anything, and went from 0 to 200 miles an hour when she found her door open to somebody in her apartment. I realized what she thought was her apartment, but that's why it's a mistake of fact. Again, better answers would have helped her out. I don't know if they're going to find her guilty or not, but...
What were you thinking when that door began to open when you took the fob?
I was at my apartment.
When you heard rustling inside as that door opened, did you stop and wait outside and think about what you were hearing?
No, I went in.
How quickly was that happening?
Seconds.
Term she wants to use is I reacted instinctively. I didn't really stop and think about it. It happened so quick. It was just reactive and instinctive movements. It wasn't, it's not like I was expecting this. I got a call. I was able to ride up. I was able to set up a perimeter. It wasn't anything like that. I was in a relaxed state going home, not expecting anything to happen. And it went from that to there's somebody in my apartment, my door's open. Oh my God, my life's in danger. Those are better answers, in my opinion. I know I'm with people here.
What was your thought when you thought you were going in your home and the door opened?
And somebody was inside.
Were you thinking as a policeman answering a burglary call at all?
I was thinking I was relaxed right before, and all of a sudden I come home and then there's somebody inside my apartment. My
That's a good, honest answer.
heart rate just shot up.
All these other things Mr. Ernest asked you about calling for backup or retreating to cover, any of that in your mind when you were face to face with this person you saw in the back?
No, I didn't have to. I was going home. It wasn't a call.
There was no time for any of that. Everything progressed at such a rapid pace. I barely had time to get my gun out. All I was trying to do was see his hands. It was dark. There was somebody moving. I thought it was in my apartment. That's not a lot of time. I'm saying a few seconds. It might have even been less than a few seconds. It's just, if you ask somebody how long when they were in a wreck, they wouldn't know because it happened so quick, and you kind of like lose time a little bit.
Mr. Herman said, had you estimate times? Did you have a stopwatch at all? Were you timing any of this, or what was happening?
No, sir. It was just happening quick. It was quick. That's all I can say. It was seconds.
Okay, sometimes I got a little irritated with attorneys that cross-examine me over shit that didn't matter. So I'm okay with where he's going now. I don't know where he's going to go. But when attorneys get a client on the stand and you're looking good or it's okay, you want to get them off the stand. This DA is only allowed to ask her questions on direct of this examination. So anything that this attorney brings up about this incident, the DA can do follow-up and ask questions and go in different areas off those subjects. If you keep it short and you only give the DA 2 things, then you limit your client's exposure on a stand. It used to irritate the hell out of me on a case that kind of had some issues, and I really didn't want to get into those issues, and the attorney questioned me, and I got off the stand without getting into those issues, and my attorney, the DA, would ask me questions and want to cross-examine me, and I'm like, dude, just get me off the stand. We're sitting good. There's no reason to go any further. And he'd go in, blah, 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 on the things that he knew an answer to, and he would open the door for the defense attorney to ask all these other questions now. So then I'd have to sit up there and ask all these other questions, and I'm like, ooh, cool. He didn't bring up the iffy situations that would be problems. Not that we did anything wrong or illegal. It was just, it would muddy the waters, and it didn't really matter. So I answered his questions, and I'm ready to get off the stand, and the freaking DA would want to ask me a couple other questions, and I just look at him like, you freaking idiot. Let's quit while we're ahead. Why do you want to keep prolonging this and giving the defense more places to go? So that's something to be aware of. If you cross-examine somebody or if you're on a stand, everything that this attorney is asking her now, the DA is taking notes, and now you have opened the door for him to do more examination. If he asks one thing, then the DA can only ask things about that one thing. If you ask 10 things, now the DA gets to ask about those 10 things. So I think the attorney kind of messed up here. I don't even know where it went or what he did, but you got your client up there, touch on some very specific things, and get her off the stand. Don't give the DA more time and more places to go with her. You've already seen what he can do with just a little bit of time with her. Why the hell do you want to give him more time? Get your client off the freaking stand with minimal damage.
And when you saw this figure, this person dancing toward you, correct?
Yes, sir.
Where was this person when you made the decision to shoot?
Right in front of the armrest of the couch, but in front of the counter still.
Somewhere in this area?
Yes, sir.
Not to mention, she's been up there for a long time. Get her off the stand. Her head isn't straight. I might have been able to say, you know what? I'd like a recess before I start my cross on her, or before I start my examination on her. Give her a time to decompress. Talk to her. Say we're going to clear up a couple things. Here's where I'm going. Here's what I'm trying to get out to the jury. Here's what I want the jury to hear. Then put her back on the stand. I probably would have think that would have been a better move, but I'm not the attorney on this case, so.
And when you made that decision to fire in this area, how many feet? I've measured this off and I've talked about it. 12, 13, 14, 15 feet.
12, 15 feet.
The area I'm in now.
Yes, sir. From where I was standing.
That was the distance between you and him.
Yes, sir.
Something I really think he needs to get out is where she said you meant to kill him. I would absolutely approach that and say, you testified with the DA kind of pressuring you or leading you into saying you meant to kill him. I want to approach that topic. Isn't it true that you're trained to shoot for center mass and to stop the threat? Yes. At any time during your training, did they use the word kill? No. Is it fair to say that you, when you went to your apartment, you went home, you weren't looking to kill anybody? No, I wasn't. And is it fair to say when you shot him, you would rather him be alive than dead, wouldn't you? Yes. You said you were sorry to the family, didn't you? Yes. You said you know that he shouldn't be dead. Yes. But yet you testified that you meant to kill him. I'm confused. What did you mean, or why did you say you meant to kill him when I think you meant to shoot center mass and stop the threat? Give her a chance to clear that up. Give an alternative theory to the jury so the jury knows that she kind of misspoke on that topic. Now, some lawyers may go, you know what? That was a bad statement. I don't want to approach it with a 10-foot pole. I want them to forget it. I'm not going to bring it up. I think it's better if you at least get the questions on how she was trained and that we're never taught to kill and that she's sorry she killed him and she did not want to kill him when she went home. I think those would be good statements and good questions. Some attorneys may not think that would be a good idea. That's just me. What the attorney is doing right now is going through his notes.
Talked on direct, Mr. Hermes asked you questions about the tone of voice you said when you said, let me show your hands. Let me see your hands.
It sounds like he's touching on the things to where he kind of implied she was lying, and he wants to cover those areas. What I was going to say is he's going through his notes. He probably made notes like, I need to handle this on direct. I need to cover this issue. I need to cover this issue. I need to cover that issue. So when you hear him over there fumbling, that's kind of what he's trying to figure out. And it may have been a quick note, so he may be like, it could have said outside voice, cross on that. So when he read that, he might have had to think for a little bit, what exactly did I want to say on this outside voice? I put a note, so I need to question her about it, but I'm not sure. So that's why there's a long pause with him, because he's kind of making up these questions on the fly during the examination by the DA.
Yes, sir, I did.
The volume that you used when we demonstrated, is that the volume you used?
That he used?
That you used?
Yes, sir. It was clear and precise.
You've heard the state's allegation that you're just lying about that you said no.
I did. But I know I said I know what I did and what I said that night. And I did say, let me see your hands, let me see your hands.
Was he sitting on the couch at all?
No, never saw him sitting on the couch.
Was he moving? Was he just standing?
See, I wouldn't be going there. Now you're giving him a chance for her to... She's already testified that she saw him moving and he came at her. When you start trying to get her to give more specifics, now you get the DA to be able to say she changed her testimony. You didn't say that the first... Never ask the same question on cross if you're expecting a different answer. She's already testified on that. He's asking her now to give more information, and now it's going to look like she was either lying before or lying after. I do not agree with this question, but it could turn out good. I don't know.
What was he doing when you fired the shot?
He was just moving, advanced towards me whenever I shot the first two shots where he ended up falling down.
And why did you shoot?
Because I was scared that he was going to come at me and kill me.
That was your reason?
Yes, sir. I was scared, and I thought he was advancing towards me. He had a weapon.
She uses that term kill a lot. I would use the term in the law, I was in fear of my life. I don't know why she keeps using I was afraid he's going to kill me. That's not legal terminology. It's not in the definition. I don't get it, but it is what it is. I think it's better to quote the law when you're defending yourself and to say what the law says you can use deadly force for. That's how you don't get in trouble, in my book.
And then when you found out you'd shot an innocent man, what did you think?
Everything changed.
Judge, I'm going to check. This is cumulative.
See how he doesn't let him get any questions in without objecting. And yet he let the DA do whatever the hell he wanted. Wow. Good for the judge. I would have allowed it too. His objection was cumulative, which I'm not sure what that objection is, but I'm assuming he's trying to make her, he's putting a lot of facts into one. He's doing exactly what the DA did, like 30 times during his examination. And now he's objecting when this guy does it.
You started realizing that when you were calling 911?
Yes, sir.
The state of mind that what we hear in your voice and what you're saying, is that what was going?
Sorry. I object to the leading of the question, sir.
Don't lead to Mr. Shuka.
Can you describe your state of mind as you were on that 911?
My mind was racing. I didn't know where I was at. I had this guy laying on the floor. I wanted paramedics. It was so much processing through my mind. I would never want anybody to ever have to go through or even imagine going through what I felt that night. Just, you can't think, you forget so much now.
Okay, not a bad answer. It would have been better as soon as I realized that I was in the wrong apartment. I wanted to get professional help there to try and save him. And I was panicking, and I was confused, and I was still trying to figure it out. But I know I wanted to get on 911 and get help there immediately, which is why I called 911 immediately. I think that would have been a little bit better answer if she could have squeezed some of that in.
Did you in any way think you were having to give your full story as you're on the 911 with the 911 operator?
No, I just wanted someone help. I just wanted someone there as quickly as they could get there.
Why did you leave to go find those officers?
Because I could hear them, but it just felt like they were taking forever. And I just wanted to go out there and just let them know where I was at instead of searching for me.
Why did you want their help?
To get Mr. John to the hospital.
They still haven't got to the point. Why would you give CPR if he was still alive and breathing? Because I think the DA said they were on a gurney taking him to the hospital. He was fighting for his life or still breathing. Why would you give CPR to a person that was still conscious and breathing? You wouldn't. And that would kind of negate all this, she's a mean person for not giving first aid.
Hold on. Before we resume your cross-examination, we're going to take our lunch break and we'll start back at the end of 10.
Oh, that's a bad move, see? Now the defense gets to go out and plan his cross with time instead of taking the break before so he could have talked to his client. I think that's an error on this attorney. He should have asked for a break for his client so they could have went over some things. And he didn't. And now the DA gets to take a break before he goes over things. So they get to call her back and she has to go over this again. All right, I'm at 18 minutes. I'll come back when they come back.